Thank you so much for coming to this webinar. It's truly my pleasure to speak each July to our alums about what the Supreme Court did in the prior term. For the last 5 years, each July, I've written a book for the American Bar Association describing the just completed term. I always look for a theme of the decisions of the term and use it for the title of the book. Sometimes that's easy to do. If you think back 3 years ago to the term when the Supreme Court overruled Roe versus Wade, dramatically expanded gun rights, changed the law with regard to the religion clauses, I titled it A Momentous Year in the Supreme Court. My title for the book this year is Taking Sides. Our country is more ideologically divided than it's been at any point since Reconstruction. Many of the cases on the docket this term very much reflected that ideological divide. This was a term when the so-called culture wars came to the Supreme Court. This was a year when there were many challenges to President Trump's executive orders. What's striking to me is that the court very much chose sides. Now, you may agree with what the Supreme Court did, or you might disagree, but the Supreme Court was solidly on the conservative position in the culture war cases and overall with regard to the challenges to President Trump. In fact, as I think ahead to the future of the Supreme Court, I think the question of profound significance is, at a time when our country is so deeply divided, what will it mean to have a Supreme Court that's come down so solidly and consistently on one side of that ideological divide? Each summer when I do this talk, I give you some of the numbers about the Supreme Court. The Supreme Court decided 56 cases with signed opinions after briefing and oral argument. It's almost the same as last year when it was 58 decisions, and this seems the new normal, somewhere between 55 and 60 cases a year. Keep in mind, though, that as recently as the 1980s, the court was deciding over 160 cases a year. While the number of cases on the so-called merits docket has stayed the same in the last few years, the number of cases on the emergency docket, what some call the shadow docket, has increased dramatically. A year ago, the Supreme Court resolved 44 matters on the emergency docket. This year, on June 27th, the day they finished handing down opinions, there were already at that point 113 matters on the so-called shadow docket. The difference in part is how many challenges there have been to President Trump that have come before the court on its emergency docket. A couple of other interesting statistics. Of the 56 decisions, only 3 were reviewing state court decisions. All the rest were reviewing Federal Court of Appeals matters, or in some instances, matters that came to the Supreme Court in its original jurisdiction. This isn't a one-year phenomenon. Last year, it was 4 cases. The year before that, 5 cases from state courts. What it means is, if you're litigating in state court, the likelihood of the Supreme Court taking that case is incredibly small. Another interesting statistic is that of the 56 cases, 12, or about 20%, were reviewing the United States Court of Appeals for the Fifth Circuit. And the Fifth Circuit was reversed in 10 of 12 cases. I think the Fifth Circuit is staked out a position as being even more conservative than our conservative Supreme Court. The justice most often in the majority was Chief Justice John Roberts, 95% of the time. The 2 justices most often in agreement were Justice Thomas and Alito, 97% of the time. The 2 justices next most often in agreement were Justices Sotomayor and Jackson, 94% of the time. And I think it reflects that Justice Thomas and Alito are the most conservative justices. At least this term, Justices Sotomayor and Jackson were the most liberal justices. Well, I was trying to think about how to best present the cases and how to organize my presentation. And finally, I decided I would just go alphabetical by topic. I'm going to talk for about 50 minutes and then leave the remaining time for questions. There is a handout available. Hopefully, it's been put either into the chat or sent to those of you who have signed up for this. It lists the cases in the order in which I'll be discussing them. Obviously, in the short amount of time that we have together, I can only cover some of the cases of the term. I've picked what I think are the most significant for the law and for society, but I'm glad in the question and answer session to talk about others. So beginning alphabetically, it means I start with administrative law. There's no doubt that one of the greatest areas of change in the last several years has been with regard to the administrative state. A few years ago, the Supreme Court created a new principle, the major questions doctrine. It says that agencies can't act on major questions of economic or political significance without clear guidance from Congress. The Supreme Court used this to say that the Environmental Protection Agency couldn't regulate greenhouse gas emissions from coal-fired power plants. The court used to say that President Biden couldn't give student loan relief. It's led to a great deal of litigation in the lower courts because it's unclear what's a major question of economic or political significance. What's enough congressional guidance? A year ago, the Supreme Court overruled so-called Chevron deference. This is the principle that a court should defer to an agency interpretation of an ambiguous statute, so long as the agency is reasonable. If I can use a baseball metaphor, for those who want to change the administrative state, these decisions were doubles. The grand slam would be if the Supreme Court revived the so-called non-delegation doctrine. The non-delegation doctrine is the principle that Congress can't delegate its legislative power, such as to executive agencies. Only twice in history has a federal law been declared unconstitutional as an excessive delegation of power. Both cases were in 1935, Schechter Poultry versus United States, and Panama Refining versus Ryan. But in recent years, some of the justices have urged the revival of the non-delegation doctrine. In Gundy versus United States in 2019, Justice Gorsuch, in a dissent, joined by Chief Justice Roberts and Justice Thomas, urged the revival of the non-delegation doctrine. Justice Alito wrote a short, enigmatic concurrence saying, if there was a majority to revive and reconsider the non-delegation doctrine, he would join them, but there wasn't such a majority there. Justice Kagan wrote apocalyptically about what it would mean to revive the non-delegation doctrine. She said virtually every federal statute that creates an agency is a broad delegation of power, that virtually every agency could be challenged as unconstitutional if the court would revive the non-delegation doctrine. Well, the Supreme Court had a case before it this term that could have revived the non-delegation doctrine, but it didn't happen. The case is Federal Communications Commission versus Consumers Research. It involves the Telecommunication Act of 1996. It authorizes, in fact, instructs the Federal Communications Commission to facilitate broadband access, particularly in rural areas and in schools. The Federal Communications Commission then created the Universal Service Fund to collect money for this. If you look at your phone bill, you see every month you pay money to the Universal Service Fund. The FCC created a private company to administer the Universal Service Fund. Last summer, the United States Court of Appeals for the Fifth Circuit, in a 9-7 en banc ruling, found that these provisions of the Telecommunications Act were unconstitutional as an excessive delegation of power. They pointed to both the delegation of power from Congress to the Federal Communications Commission and from the Federal Communications Commission to this private company. The Fifth Circuit also talked about how the combination makes this unconstitutional. The Supreme Court, though, reversed the Fifth Circuit and upheld the federal law. Justice Kagan wrote the opinion for the court. Justice Gorsuch wrote for the dissenters. Justice Kagan said, the law has been, since the 1930s, that Congress can delegate its power if there's an intelligible principle to guide the exercise of discretion. She said here, Congress did just that, giving clear guidance to the Federal Communications Commission as to what it was to do. She said, moreover, the Federal Communications Commission clearly supervises every aspect of what this private company does in administering the Universal Service Fund. She said, this meets the requirements for permissible delegation of power. Justice Gorsuch's dissent focused on a different ground than the Fifth Circuit. He said that ultimately, this is a tax. It's about raising revenue for the Universal Service Fund, and Congress can't delegate its taxing power. The majority responded to that by saying, there's no reason to treat taxing different than any other federal power. In fact, there's two prior Supreme Court cases that said Congress can delegate revenue-raising power so long as there's an intelligible principle. This is the case of the dog that didn't bite this term. It doesn't change the law. It reaffirms the intelligible principle standard, but it certainly doesn't resolve the issue as to whether in the future the court might revive the non-delegation doctrine. The second area that I list concerns equal protection. And the case is United States versus Scrimetti, and it reflects what I said in my introduction of the culture wars coming to the Supreme Court. It involves a Tennessee law that prohibits gender-affirming care for transgender youth. Specifically, it prohibits transgender youth from being given puberty-blocking hormones or cross-sex hormones. Tennessee is one of 26 states to adopt such a law. All of them have Republican-controlled state legislatures. The federal district court issued a preliminary injunction finding that this was discrimination based on sex and discrimination based on gender identity. The United States Court of Appeals for the Sixth Circuit reversed and upheld the Tennessee law, saying only rational basis review should be used. On June 18th, the Supreme Court, in a 6-3 decision, affirmed the Sixth Circuit and upheld the Tennessee law. Chief Justice Roberts wrote for the court. Justices Thomas, Alito, and Barrett wrote concurring opinions. Justice Sotomayor wrote a blistering dissent. The key difference between the majority and the dissent was over the level of scrutiny. The majority said just rational basis review, that the law would only have to be rationally related to a legitimate government purpose. There should be great deference to the Tennessee legislature, the majority said. The dissent said this is sex discrimination. This is gender identity discrimination. It should have to be intermediate scrutiny, substantially related to an important government purpose. Why does that matter? If it's rational basis review, as I said, there's tremendous deference to the political process. The court doesn't look at the evidence for itself. But if it's an immediate scrutiny, it is a much closer examination, and the court doesn't give the deference to the legislature. Well, in justifying why it's only rational basis review, Chief Justice Roberts considered both of the arguments by the challengers, both which have held in the district court. First, is this sex discrimination? He said no, because both boys and girls are being prevented from having gender-affirming care. Both boys and girls can't be given puberty-blocking hormones. He says it's not sex discrimination. Justice Sotomayor sharply disagreed. She said boys can be given testosterone, say they have delayed puberty. It's being given for gender-affirming reasons. Girls can be given estrogen, say for delayed puberty, for gender-affirming reasons. But boys can't be given estrogen for gender-affirming reasons. Girls can't be given testosterone to correspond to their gender identity. So that's sex discrimination. The other ground of claim as to discrimination was that this is gender identity discrimination. Chief Justice Roberts said that the court wasn't going to face the issue of what level of scrutiny should be used for gender identity discrimination because the court rejected the argument that this was gender identity discrimination. He invoked a 1974 Supreme Court case, Geduldig versus Aiello. That involved a California law that provided for state employees the government would have a disability program, provide disability benefits for all medically related conditions except for pregnancy. So there are conditions that affect only women, ovarian cancer. There are conditions that affect only men, testicular cancer. The state would pay for disabilities related to those, but not if it was pregnancy. And the challenge was, the argument brought by those who were objecting to the law, was that to exclude pregnancy is sex discrimination. The Supreme Court rejected that argument and upheld the California law. Chief Justice Roberts said, Justice Potter Stewart said, there are two categories of people, pregnant persons and non-pregnant persons. The Supreme Court said, since women are in both categories, it's not sex discrimination. Well, Chief Justice Roberts responded and used Goodoldig versus Aiello. He said there's two categories of people, transgender individuals who can't be given these hormones for gender-affirming reasons, and everybody else who can be given these drugs for other reasons. He said transgender individuals are both groups. It's not gender identity discrimination. Justice Sotomayor sharply disagreed. She said Goodoldig is one of the most ridiculed Supreme Court cases in history. She quoted Justice Ginsburg that it was wrong when it was decided. And she said this is clearly gender identity discrimination. That was the whole purpose of the legislation. Justices Thomas, Alito, and Barrett wrote concurring opinions saying only rational basis review should be used for gender identity discrimination. It's worth noting that the Supreme Court has granted cert in two cases for next term, Little versus Hecox, and another case, Idaho versus BPF, that involve whether or not state laws that prohibit transgender individuals from participating in athletic events that correspond to their gender identity are constitutional or not. So the court may very well then decide what is the level of scrutiny that should be used for gender identity discrimination. The third area I list in the handout concerns the federal judicial power. And probably the most high-profile case of the year, and maybe the most important, was Trump versus Casa. On January 20th, President Trump issued an executive order to limit birthright citizenship. Birthright citizenship is the idea that everyone born in the United States is a United States citizen. That was the law in this country from 1787 until tragically in Dred Scott versus Sanford in 1857, the Supreme Court said that enslaved individuals were not citizens, even if born in the United States. When the 14th Amendment was adopted in 1868, the first sentence says, all persons born or naturalized in the United States within the jurisdiction thereof are United States citizens. This is always understood to mean that everyone born in this country is a citizen, regardless of the immigration status of their parents. In 1898, United States versus Wong Kim Ark, the court said everyone born in this country is a citizen. The court said within the jurisdiction thereof was just meant to exclude babies born to soldiers in an invading army or babies born to diplomats. Immediately, challenges were brought to the Trump executive order, and 3 federal district courts issued nationwide preliminary injunctions, keeping the executive order from going into effect anywhere in the country. The Federal Courts of Appeals upheld this. The Supreme Court granted review. It held oral argument on May 15th. On June 27th, the Supreme Court ruled in a 6-3 decision that federal courts generally cannot issue nationwide injunctions. Justice Amy Coney Barrett wrote the opinion for the court. Justices Thomas, Alito, and Kavanaugh wrote concurring opinions. Justice Sotomayor wrote a dissent joined by Jackson and Kagan, and Justice Jackson wrote her own dissent. It's worth contrasting the difference in approach between the majority and the dissent. They disagree about methodology. Justice Barrett began her opinion by saying, this is a case about statutory interpretation. Under the federal jurisdictional statutes that create and empower federal courts, can they issue nationwide injunctions? And she said, we answer this question by looking at the power of the Court of Chancery in England before the Constitution was written. And she said the Court of Chancery didn't have the authority to issue nationwide injunctions, so federal courts weren't meant to give them that power. The dissent strongly disagrees that's the right question. Justice Jackson, in her dissent, says, the Court of Chancery in England couldn't stop the king from violating the law. Why should we be looking to it? Justice Sotomayor says that courts of equity have traditionally had broad powers to fashion remedies. Why should we deviate from that here? Second, the majority and the dissent disagree, but what's been the history subsequent to 1787? Justice Barrett says, nationwide injunctions didn't exist until 1963. They've only become common in more recent years. Justice Sotomayor disagrees in terms of the history. She says nationwide injunctions have existed at least since the early 20th century. She have a number of examples. And she said the fact that they become more common doesn't suggest they're illegal. Perhaps most of all, the majority and the dissent disagree in terms of whether or not the consequences should be considered. Justice Barrett says, we are just deciding the meaning of the statute. Does it empower federal courts to issue nationwide injunctions? We're not going to be looking to the consequences of this. But for Justice Sotomayor and Jackson, it was all about consequences. It's about how plaintiffs will need to file lawsuits in 94 federal districts. It's about even after several districts have deemed something unconstitutional, the president can continue to do it elsewhere until there's a Supreme Court ruling for the whole country. The dissent lamented the likelihood that this could lead to a patchwork, where the law would be different, varying in the districts. But most of all, the dissent expressed great concern about lessening the ability of the federal courts to check the president. Justice Jackson spoke powerfully about this being a threat to the very core of the rule of law. I think the significance of this case is likely to turn on whether or not there's ample alternatives to restrain unconstitutional presidential action. Can there be nationwide class action suits? Can states have third parties standing to sue on behalf of their residents? Justices Thomas and Alito wrote separately to say that they do not believe that nationwide injunctions or states suing on behalf of their citizens should be able to be used to achieve the same effect. But the majority opinion left that open. Justice Kavanaugh, in his concurring opinion, said, the real solution is just bring it all to the Supreme Court on its emergency docket. He said, we're open 365 days a year, 24 hours a day. We'll decide all of the issues. Last Thursday, a federal district court in New Hampshire certified a nationwide class to challenge President Trump's executive order on birthright citizenship and issued an injunction. We'll see perhaps through this case, can nationwide class action suits pursuant to Rule 23B, the Federal Rules of Civil Procedure, suffice? Can a state suing on behalf of all of its residents provide a substitute? Or should we fear, as Justice Sotomayor and Jackson said, that we've substantially weakened a crucial check on the president and a way to enforce the Constitution and laws of the United States? The fourth area that I list in the handout concerns the First Amendment and religion. This, too, is an area where the law has changed a great deal in recent years. For decades, the Supreme Court took a robust approach to the Establishment Clause of the First Amendment. It saw it as embodying the words of Thomas Jefferson, that there should be a wall separating church and state. But in recent years, the court has greatly relaxed the requirements of the Establishment Clause. Little now seems to violate it. On the other hand, the court had been very lenient in terms of what violates the Free Exercise Clause. The court had said, we're not going to create exceptions to general laws, people on account of their religion. But in recent years, the Supreme Court has made a much more robust law with regard to the Free Exercise Clause. There were 3 cases this term about the religion clauses. 2 were decided, and 1 is an issue that's left to be resolved. The first case is Catholic Charities Wisconsin Labor and Industry Review Commission. Wisconsin, like almost every state, imposes an unemployment insurance tax on employers. It uses it to fund its unemployment insurance program. Wisconsin, like many states, gives religious entities an exemption from paying the tax. The law says that entities that have, quote, a religious purpose don't have to pay the tax. Catholic Charities is an entity that exists apart from the Catholic Church. It exists to provide social services. It will provide the social services to people of all religions. And when it provides the social services, It's not engaged in religious teaching or indoctrination. The Wisconsin Commission said it doesn't qualify as an entity that exists for a religious purpose. It exists to provide social services. The Wisconsin Supreme Court affirmed, but the United States Supreme Court unanimously reversed. Justice Sotomayor wrote the opinion for the court. She said, if the government is discriminating among religions, the government must meet strict scrutiny under the Establishment Clause of the First Amendment. She said, this is discriminating among religions. She said, if Catholic charities had engaged in religious education, indoctrination, then it would count as existing for a religious purpose. But because proselytization is inconsistent with the Catholic faith, it doesn't get that benefit. She said, this is giving the benefit to some religions over others, strict scrutiny, and the law fails. The court reaffirmed that the Establishment Clause still has relevance if the government is discriminating among religions. And here the court recharacterized the case as being one about discrimination among religions. But underlying the case is an enormously difficult issue. How is religion to be defined? How do you determine what's a religious purpose? The Supreme Court has always avoided those questions, and they did so here. But the more the government gives exemptions to laws on account of religion, the more it's going to be necessary to face the seemingly impossible question of defining what is religion. The second case I listed in this category, Mahmoud versus Taylor, is another that brought the culture wars to the Supreme Court. Montgomery County, Maryland, adopted a curriculum with regard to sexuality, sexual orientation, and gender identity. It started at young ages and went through school. The curriculum presented gay, lesbian, transgender individuals in a favorable light. A group of parents of young children who objected to the curriculum on religious grounds brought a challenge based on free exercise of religion. They said that they should have a First Amendment right to notice and to opt out. The United States Court of Appeals for the Fourth Circuit ruled against them, but the Supreme Court 6-3 ruled in favor of the parents in their claim of free exercise of religion. Justice Alito wrote the opinion for the court, and here too it was Justice Sotomayor who wrote a very strong dissent. Justice Alito said, it's well established that parents have the right to control the religious upbringing of their children. If the government substantially interferes with that, the government has to meet strict scrutiny. He said, here the parents believe that exposing their children to this material about sexuality, sexual orientation, gender identity was inconsistent with their religions. Thus, the court said strict scrutiny is to be used, and the court said that the government failed strict scrutiny, that the parents have a First Amendment right to notice and opt out. Justice Sotomayor, in her dissent, said in part, this is the first time that the Supreme Court has ever said that mere exposure to materials is enough for violation of free exercise of religion. But then she said, this is going to cause chaos in the public schools. There's no limiting principle in the majority's opinion. So does this mean that any time evolution is taught in science or biology, parents have to have notice and the ability to opt out? Does this mean that any time an English class has a book where there's witches or witchcraft, like Harry Potter or The Wizard of Oz, parents have notice and opt out? Justice Sotomayor said, some parents, based on the religion, believe that women should not work outside the home. Does that mean that parents have to notice and opt out anytime there's a presentation in a positive light of women working outside the home or of mothers? She said, how are schools going to even know when they have to give notice? And if we require that schools let people opt out, will that mean that schools are then just teaching that which nobody's going to object to? So I think this is a case that's going to lead to an enormous amount of litigation because it really opens the door to parents being able to say, for anything they object to on religious grounds, I should even notice, I should have the ability to opt my children out. And now, of course, it may mean, on the other hand, is some school systems, like Louisiana and Texas, or doing more to bring religion to the classroom might provide a basis for those parents to opt out as well. The other case that wasn't decided is Oklahoma statewide charter school board versus Drummond. In recent years, the Supreme Court has said for the government to provide aid to secular private schools, but not religious schools, violates free exercise of religion. So in Trinity Lutheran versus Comer in 2017, the court said for Missouri to give aid to private secular schools and public schools for surfacing playgrounds, but not to religious schools, violated free exercise. In Espinoza versus Montana Department of Revenue in 2020, the court said, for Montana to give tax credits to people who are sending their children to private secular school, but not to religious school, violates free exercise. In 2022, in Carson versus Macon, the Supreme Court said, for the state of Maine to provide aid to send children in rural areas to private schools, but only secular, not religious schools, violates free exercise of religion. It was immediately obvious that the next set of cases are going to involve charter schools. Charter schools are schools created by state law. They're funded by the government, but they're privately run. The Archdiocese in Oklahoma wanted to create 2 religious charter schools. Oklahoma law, like that in every state, prohibits religious charter schools. Nonetheless, the Oklahoma board that approves charter schools said they could do so. The Oklahoma Supreme Court said it would violate the Oklahoma state constitution to have religious charter schools. The matter went to the Supreme Court. Only 8 justices participated. Justice Barrett recused herself, and the Supreme Court, after oral argument, announced it was split 4-4. When the court is split 4-4, it means that the lower court is affirmed by an evenly divided court without there being a precedent. So the issue is sure to come back to the Supreme Court. Should we think of charter schools as public schools? Should we think of them as private schools? And that characterization is likely to determine the outcome. And I think the one thing that seems certain is that the result is going to depend on one justice, Amy Coney Barrett. I have no doubt that lawyers will put her picture on the front of their briefs. They'll make their briefs a shameless attempt to pander to her. The 5th area I listed concerns the First Amendment and speech, and there are 2 cases. The first got a great deal of attention, TikTok versus Garland. In the spring of 2024, Congress, in a bipartisan manner, passed a bill that said that TikTok could not operate in the United States after January 19th, 2025, unless it was sold to a non-Chinese owner. TikTok is owned by ByteDance, a Chinese company. President Biden signed it into law. 173 million people in the United States use TikTok. Never before had Congress tried to outlaw a platform of communication. Challenge was brought by those who post on TikTok and those who use TikTok. In December, the United States Court of Appeals for the District of Columbia Circuit upheld the federal law and rejected the First Amendment challenge. The Supreme Court granted expedited review. It heard oral argument on Friday, January 10th. It handed down its decision on Friday, January 17th. The court unanimously affirmed the D.C. Circuit and upheld the law. There's a per curiam opinion, an opinion of the court. Justice Cicero and Gorsuch wrote short concurrences. The Supreme Court said intermediate scrutiny should be used since this was a content-neutral restriction of speech. It wasn't content-based, targeting a particular viewpoint or topic. The court said that the government has an important interest in national security. The United States government said to the Supreme Court that if TikTok is owned by a Chinese company, then China can obtain information about who's using TikTok and what they're watching. Now, I think the Supreme Court accepting this argument fits a long tradition of the Supreme Court deferring to the government when it claims national security. After all, ask yourself, how is it going to hurt national security for TikTok to know, for the Chinese government to know what dance videos people are watching? What is the basis for believing that having access to this information will be inimical to the country's security. I read the briefs, I read the decision, and there's no explanation of it. The next day, January 18th, TikTok went dark in the United States. But on Sunday, January 19th, President Trump said he wasn't going to enforce the law against TikTok. There's a provision of the statute that says the president can extend the law for 90 days if there's substantial progress towards a sale. President Trump didn't invoke that provision. And twice more, he's extended it. Attorney General Pam Bondi has told the tech companies the federal government's not going to enforce the law. Maybe there's a precedent of this, but I can't think of what it is. Where Congress overwhelmingly adopts a statute, the Supreme Court unanimously upholds it, and then the president, with no authority under the law, just says, we're not going to enforce it. We're going to pay no attention to it. But that's where we are now. The other First Amendment case is Free Speech Coalition versus Paxton. Texas adopted a law that said, as for websites where 1/3 of it is sexually explicit content, they must do age verification. The Supreme Court precedents in this area were conflicting. In 1968, in Ginsburg versus New York, the Supreme Court upheld a New York law that said those under 18 couldn't buy sexually explicit material. This was about the ability of minors to buy magazines that were held behind the counter in the drugstore. But then in 2004, in Ashcroft versus American Civil Liberties Union, the Supreme Court declared unconstitutional the Child Online Protection Act, a law that said that websites that had sexual content had to do age verification. Justice Kennedy wrote for the court and said, the government can't restrict the material available to adults so as to protect children. The court said requiring age verification would do that. The Supreme Court, in a 6-3 decision, upheld the Texas law. Justice Thomas wrote the opinion for the court here. Justice Kagan wrote the dissent. Justice Thomas's majority opinion said intermediate scrutiny should be used. Substantially related to an important purpose, the government doesn't have to use the least restrictive alternative. Justice Thomas said, Texas has an important interest in protecting children from exposure to sexual material. He said, since it's an immediate scrutiny, the government doesn't have to use the least restrictive alternative. The Supreme Court has said since the 1950s that obscenity is a category of unprotected speech. It's interesting here that the court seemed to create a new category, material that is, quote, obscene for minors, and said that the government, to protect children, can do age verification of such material. Justice Kagan strongly disagreed. She said strict scrutiny should be the test. She said, when the government regulates speech based on content, strict scrutiny is the test. Whether the law applies depends on the sexual content of the material. And she said Ashcroft versus ACLU should control here. It used strict scrutiny. And the reason it matters is if it's strict scrutiny, the government has to use the least restrictive means. And there's no claim that this would meet that test. The dissent would have struck the law down on that basis. So what it means is that states have latitude to regulate sexually explicit material over the internet. This applied if it was 1/3 of the content, but what if it was 20%? What if it was any? Can there still be age verification requirements, even keeping in mind that the practical effect is to restrict the ability of adults to have access to the material? The sixth and final area that I list in the handout concerns presidential actions in the emergency docket. I've already talked about one of these when I discussed the nationwide injunction case, Trump versus Casa. Let me quickly talk about a few others. One concerns firings. In 1935, in Humphrey's Executive versus the United States, the Supreme Court said that Congress can create federal agencies, and Congress can provide that the commissioners of the agency can only be fired for cause. Humphrey's Executive involved the Federal Trade Commission, and there the law provided that the commissioners could be fired only for cause. The Supreme Court unanimously upheld that. President Trump has been explicit in his executive orders that he doesn't believe that Humphrey's Executive is the law or should continue to be followed. He fired Gwen Wilcox, commissioner on the National Labor Relations Board, and Kathy Harris, head of the Merit System Protection Board, even though they were protected by statutes in ongoing terms. There was no claim of cause. The United States Court of Appeals for the D.C. Circuit, in a 7-4 en banc ruling, came down for Harris and Wilcox. They said, we have to follow Humphrey's executor until it's overruled. But the Supreme Court, in a 6-3 ruling, overturned the D.C. Circuit. The majority said they believed that the Trump administration was likely to prevail on the merits. Justice Kagan, in dissent, said, what this means is that the Supreme Court is implicitly overruling Humphrey's executor, and the president may fire any executive branch official. President Trump says it's a unitary executive, and he should be able to fire anyone in the executive branch. And it appears, at least at the head of the agency officials, the court was agreeing. The result is Wilcox and Harris have now been fired. The litigation continues. The other matter that I list here is Trump versus American Federation of Government Employees from July 8th. It's Tuesday. President Trump announced that there was going to be massive layoffs from many federal agencies. Federal District Court Judge in San Francisco, Susan Ilston, issued a preliminary injunction. There are statutes, like civil service laws, that prevent firing of government employees. The Ninth Circuit affirmed Judge Ilston. The Supreme Court, though, last Tuesday, 6-3, reversed and said that the firings could go forward. They said again, there's a likelihood that the Trump administration would prevail on the merits. Once more, strong dissenting opinions. But I take these two cases as likely establishing that the Supreme Court will accept the unitary executive theory, that it will allow the president to fire anyone in the executive branch of government, even when there's statutes that provide protection. It well could mean that even civil service laws that have protection for firing from government workers, laws that have been on the books since the late 19th century, will be unconstitutional. A second area concerns cutoff of funds. There have been so many instances where President Trump has cut off funds. It's argued that's unconstitutional. Congress has the spending power. The president can't refuse to spend money appropriated by statute. Also, there's a federal law, the Impoundment Control Act, that says the president can't refuse to spend funds. There are now dozens of district court orders that the fund cutoffs were illegal and the money has to be restored. Two of these have made it to the Supreme Court, and interestingly, they came out in opposite ways, which caused a good deal of confusion in the law. Department of State versus AIDS Vaccine Coalition involved President Trump cutting off money for USAID. A federal judge in Washington ordered the money be restored. The Supreme Court 5-4 affirmed the district court's power to do this. The majority was Chief Justice Roberts and Justice Barrett, Sotomayor, Kagan, and Jackson. Justice Alito wrote a strong dissent, saying it was, quote, stunning that the Supreme Court would allow a judge to order the president to spend money appropriated by Congress. That happened on March 5th. On Friday, April 4th, there was Department of Education versus California. The Trump administration cut off $65 million of teacher training grants. A federal district court in Boston issued a temporary restraining order. The First Circuit said appellate courts aren't supposed to review temporary restraining orders. They're supposed to wait until there's a preliminary injunction. But the Supreme Court nonetheless took it up, and 6-3 reversed the district court. I'm sorry, 5-4 reversed the district court. The five in the majority were Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, the four dissenters from the earlier case, plus Barrett. And of course, the dissent here was Chief Justice Roberts, joining the liberal justices, Sotomayor, Kagan, and Jackson. The Supreme Court said, this looks to be like a breach of contract. Breach of contract actions have to go to the Court of Claims. They can't go to federal district court. And they said, if the federal government's ordered to spend the money, and then that's found to be wrong, how will the federal government get the money back? The dissenting justice said, this isn't an action for breach of contract. It's an action for violating constitutional laws of the United States. Those don't have to go to the Court of Claims. The district court said, if we're going to balance equities, what about all the people who have lost funding? I can't reconcile these two cases. Only one justice was in the majority in both, Justice Barrett, and she didn't write an opinion in either. There's a lot of lower court litigation going on, including faculty on behalf of faculty at the University of California, that involves when are cutoffs of funds by the president illegal? When can courts stop it? The final area that I want to talk about, let's do it briefly, involves the tensions in the Alien Enemy Act of 1798. The Alien Enemy Act of 1798 says that if the United States is in a declared war or there's an imminent invasion, quote, males over the age of 14 can be summarily deported to the country that we're fighting against. This law has been used 3 times in the War of 1812, World War I, and World War II. President Trump invoked it, take individuals who are in the United States, allegedly part of a Venezuelan gang, and move them to, among other places, a maximum security prison in El Salvador. The Supreme Court in JGG versus Trump said that those who are being detained who wish to bring a challenge, such as the writ of habeas corpus, have to do so in the district where they're being held. So if they're being held in a detention camp in Texas, they have to bring their habeas petition in Texas. The Supreme Court then followed that up with AARP versus Trump. This doesn't involve the organization that represents seniors. Rather, it was some individuals who were being held in Texas who said they faced imminent deportation to El Salvador. The federal district court denied relief to those individuals. The Fifth Circuit had it pending, and about 1 a.m. on a Saturday morning, the Supreme Court 7-2 said, don't take any more people to the maximum security prison in El Salvador until there's a further judicial order. And the Supreme Court reaffirmed that. It's one of the few instances where the Supreme Court has ruled against the Trump administration on the shadow docket. Another instance in which they did was the Nome versus Abrego Garcia case. This involved Kilmar Abrego Garcia, a man from Maryland. The government went to move him and did to a maximum security prison in El Salvador. A lawyer for the Justice Department said to the district court that he was taken and moved there by mistake. That Justice Department lawyer then got fired. The district court ordered that the government facilitate and effectuate his return to the United States. The Fourth Circuit agreed. The Supreme Court affirmed, it was unanimous. The Supreme Court said the district court can order that the government facilitate his return. We don't know what effectuate means, and that has to be used consistent with the president's control over foreign policy. It went back to the district court. She held contempt proceedings. Ultimately, Abrego Garcia was returned to the United States. He was arrested. He was in custody facing prosecution. I think what may be most significant is the brief that was filed by the Solicitor General in this case. The brief says, once somebody is put in a prison in El Salvador or any foreign country, no federal court has jurisdiction. No federal court can order that the president facilitate or effectuate return because the president has control over foreign policy. Fourth Circuit Judge J. Harvey Wilkinson, a conservative judge, a Reagan-appointed bench, said that if the government has this power, it could then take anyone, citizen or non-citizen, and put them in a maximum security prison in El Salvador, and there'd be no judicial recourse. Well, these cases, I say, were losses for the Trump administration, but they're puzzling losses in light of a victory the Trump administration received just a couple of weeks ago. This was on Monday, June 23rd. And the case is Department of Homeland Security versus DVD. It involves the Trump administration taking individuals from Venezuela and Cuba and moving them to South Sudan. Federal law specifies when a person is being deported where they are to be taken to. And ideally, they'll be taken back to the country they came from. They may get their country of birth, but only as a last resort does the government get discretion where to take them. A federal district court in Boston found that taking these individuals from Venezuela and Cuba and moving them to South Sudan violated the law. It was also taking them to a place where they likely could face torture or death. The First Circuit affirmed, but the Supreme Court, in a 6-3 decision, reversed and gave the Trump administration the power to do this. What's striking to me here is there was no opinion of the court. There was no majority opinion. Not a word was written of explanation. Justice Sotomayor wrote a scathing dissent about the government having this power to take human beings and to move them in violation of federal statute to a place where they could face torture or death. So that's what the Supreme Court has done on its so-called shadow docket with regard to President Trump. Those are the major cases of the term. And I've left almost 10 minutes, as I promised, for any questions you have about these cases, or if there are other cases I didn't talk about, I'm glad to discuss those. And I will let my terrific assistant, Whitney Mello, pose the questions.
Thanks, Erwin. We've got a good list here. So let's start off with this one. Does Justice Kavanaugh's offer to bring all nationwide issues to the emergency docket mean the Supreme Court would be able to, and even more likely, to decide these contentious issues without providing a full opinion with thorough reasoning?
Yes. What Justice Kavanaugh says is the issue of nationwide injunctions is really about what should happen between a district court declaring unconstitutional and the time it comes to the Supreme Court. Should there be a nationwide injunction in the interim? He says the solution is just come to the Supreme Court sooner. Now, there are many things to criticize about the court deciding things on the emergency docket. There's not full briefing. There's no oral argument. Sometimes, like in the last case that I just mentioned, Department of Homeland Security versus DVD, there's no explanation from the court at all. They didn't write a word in an opinion justifying it. I'm also troubled that when the court decides things on the shadow docket, they seem to ignore the standards of review. A preliminary injunction is only supposed to return for abuse of discretion, something that seems to get less weight there. So yes, I think that would be the implications of Justice Kavanaugh's position, and that's why I'd be troubled by it.
Criminal law didn't get a heading. Prognosticators, not you, have forecast that the court's attention will be turning to the criminal area. Those of us who work in this area fear this, including, I'm assuming they meant to say, the overturning of other established precedent, such as Matt versus Ohio and the exclusionary rule, Miranda, and other procedures to discourage unlawful police misconduct. Should we be afraid?
Yes, but qualified too. Let me talk about, you're right, as much as the Supreme Court's overall docket has gone down, the criminal procedure docket has gone down even more. The court hasn't had a Fourth Amendment case in the last several years. There is one on the docket for next term, Cade versus Montana, that involves the community caretaking, the emergency exception to the Fourth Amendment, let somebody enter a house, police enter a house without a warrant. There wasn't a Fifth Amendment case about self-incrimination this year. There hasn't been a case about eyewitness identification in over a decade. I think in part this reflects the Supreme Court taking so few cases from the state courts. That's where most criminal prosecutions go on. And also I think reflects that the majority of this court just isn't that interested in criminal law and procedure. That's why I say, no, I don't know how worried to be, because I think this court has, as every court does, a clear agenda of what they're interested in. It's not criminal law and procedure. That said, I am always worried that this court might overrule the exclusionary rule. In 2006, in Hudson versus Michigan, there were 4 votes to overrule the exclusionary rule. It was Justice Scalia writing, joined by Chief Justice Roberts, Justice Thomas, and Justice Alito. Since then, the court's become even more conservative. Might they? There was a Supreme Court case a few years ago, Vega versus Tico, that suggested that the court might be willing to rethink Miranda versus Arizona. So I think it's possible that this court, which cares relatively little about precedent, might revisit those landmark rulings, but there's no indication so far they're doing so. Even the case next term on the court's docket about the Fourth Amendment, Cade versus Montana, is about a very specific aspect of the Fourth Amendment in terms of when can police enter a home without a warrant when they're doing so in an emergency.
Are there still originalists on the Supreme Court? If so, how consistent were they to the principles of originalism in the just completed term?
There's no doubt that at this point, Justices Thomas, Gorsuch, Kavanaugh, and Barrett are self-avowed originalists. Justice Alito is always with them, though he tends to write a little less in originalist terms. And Chief Justice Roberts seems to be not a committed originalist, but often coming to the same result. The thing about originalism, I believe, is that the court conservatives will follow it when it gets the results that they want and ignore it when it doesn't get the results that they want. I think a clear indication of that was a couple of years ago in Students for Fair Admission versus President Fellows of Harvard College, where the Supreme Court ended affirmative action, and as the dissent pointed out, paid no attention to the history of the 14th Amendment and what the Congress that ratified it had done. Another problem with originalism is it's so hard to use it to deal with the kinds of issues that the court's grappling with now. Let's take Mahmoud versus Taylor. Does it violate free exercise of religion to have children exposed to material in public schools that their parents object to? Public schools, as we know them today, didn't exist in 1791. Or take United States versus Scrimetti. It's absurd to ask, what did the framers of the 14th Amendment think about gender-affirming care for transgender youth? So you don't see very much discussion of originalism. The closest you see, and it's not really about originalism, is how the court dealt with the nationwide injunction case. It's a statutory case, not a constitutional case. But Justice Barrett begins her opinion by saying, we look in deciding the power of federal courts today at what courts of chancery in England could do prior to 1789. The dissent, as I said, really objects to that. Even if the courts didn't have the power, why assume that the framers meant to reject it? And why should we be bound today by what English courts were doing then? So there you find something that very much is like originalism.
I think we have time for one more question, and after that, we'll put Erwin's email in the chat. So if we didn't get to your question, you can send it directly to him, and he will do his best to get back to you. Do you have an opinion on how the Supreme Court will decide the following two questions? Birthright citizenship and the scope of the president's tariff powers.
As to birthright citizenship, I think that the Supreme Court is going to hold the Trump executive order unconstitutional. And I think this is a place where the Trump administration is going to lose in the Supreme Court. The reason is, here you've got text, the first sentence of Section 1 of the 14th Amendment. Here you have history, starting with the beginning of the country. Those born in the United States were always deemed United States citizens. You have precedent. You have United States versus Wong Kim Ark in 1898. You also have unbroken practice. Justice Sotomayor in her dissent in Trump versus Casa pointed to at least 4 Supreme Court precedents that said everyone born in the United States is a United States citizen. As to the latter question, I think it depends. The latter question was, what about President Trump's power with regard to tariffs? I think it's a much harder question. And I don't have a prediction there. Here's why. The statute gives the president to set tariffs in an economic emergency. What does economic emergency mean? Will the court say, since this is really about foreign policy, we give deference to the president? Or will the Supreme Court say, we define economic emergency, and that's not what the statutes had in mind? So, whereas for birthright citizenship, I think it's clear the Supreme Court will rule against the Trump administration. It's the tariffs, I think it's a much closer question, and I don't have a prediction.
Great. I think it's 1 o'clock, so it's time for the day, but Erwin's email address is in the chat, and for those of you who can't see it, it is Chemerinsky, ECHEMERINSKY @berkeley.edu. Erwin, any last words?
Thanks to everybody for coming and watching. And if there's interest, we'll do it again next year for October term 2025.